on this platform. I think discussing how to empower workers and understanding the rights and responsibilities on May 1st is actually a very good idea. So we dig in a little bit deeper into issues surrounding employment, labor, and industrial relations. So I thank everyone, and of course, I'm glad to be on the same panel with Bashman and Leonard Silk in Wilson as well. People who in their own rights, have done a lot in this sector. So of course, also a privilege to be the one to start. So I expect that as the other speakers come behind me, they'll even be able to, expand the more on the few thoughts I'll be sharing. So my role this afternoon is to look at the first sub-theme, which is legal frameworks and rights. Understanding labor law and regulation, the right of employees in the formal and informal sectors, and legal protections against discrimination, harassment, and unfair dismissal. So I'll start first of all by just giving a quick overview of the legal framework and the rights when it comes to labor and employment laws, and particularly understanding how we can empower workers the more, because we all agree that without workers, the national productivity and the economic grinds to a halt. And it's also important to always have at the back of our minds that beyond being a commercial issue and economic issue, labor or employment or workers' rights is also in itself a human right as well, because beyond the fact that the output of workers contributes to economic activity for most workers, or for every worker essentially, work itself becomes a source of livelihood and a source of, giving any sort of vent to their fundamental human rights and fundamental aspirations as human beings. So, that's always the balance when it comes to labor and employment law, that while for the employer, it's sometimes largely just a commercial and economic undertaking, for the worker, it's his very livelihood, it's his very life, it's the very basis on which he, has any aspirations, to life. So it's always good to strike that balance. So of course, when we talk about the legal framework for labor and employment law, we'd always have to start with the Constitution, because the Constitution, of course, so far as Nigeria is concerned, is the ground norm and where every law takes its bearing from. Of course, one of the major ground-breaking things when it comes to the rights of workers and employment law generally is the third alteration. But before I go to the third alteration, it's important to note some of the basics. When you look at the Constitution, you have to remember that labor law or labor and employment matters is listed as item 34 in the second schedule as the exclusive list. So therefore, it's a federal matter. That is why, of course, the primary law on labor is the Labor Act, which is a federal statute, passed a long time ago, and still retains its currency under the Constitution, up until now. But within the Constitution itself, there are several sections also that have great impact on workers' rights. So there's Section 33, for instance, which prohibits forced and compulsory labor. So internationally, we have a lot of talk about modern day slavery. So I would say the equivalent in the Nigerian Constitution is Section 33, which prohibits, putting people in any form of employment that the person has no right to really determine the conditions of that employment. So you might have strayed into, forced or compulsory labor. Then, of course, Bashman will talk about unionization, but the framework for that also is found in Section 40, which allows for freedom of association. That largely is what gives rise to unionization and collective bargaining and all the other things that try to even the power play between employers and employees. Now, we come to the Third Alteration Act. Why the Third Alteration Act is considered such an important watershed in Nigerian labor law is that with the Third Alteration, amongst many others, first of all, it harmonized the National Industrial Court into the list of superior courts of record listed in Section 6 of the Constitution, and therefore situated them properly within the Nigerian court system, because before then, of course, we are aware that the Supreme Court had come to a conclusion that that the industrial court did not have the decision it claimed to have, and that almost undid all the work of the industrial court until the third arbitration came and saved the day. But the other very important part of the third arbitration is the fact that it now allows the industrial court to apply, international conventions, and also international best practices. It's a whole field, and we won't delve into all of that, but we'll just touch a few of them that are relevant. But it's a huge issue. But there's a very interesting. Okay, of course. So we know that when the third arbitration act came, there was still some uncertainty as to right of appeal from the industrial court. So the initial understanding that arose at a point, reading just the third arbitration alone, was that the industrial court was a first and a final court in employment and labor law matters. So that raised quite a lot of issues at the point, because it was almost viewed as this court was even more powerful than the Supreme Court, because even the Supreme Court, that is the final court in the land, is usually not the court of first instance. But here we now had what looked like a court that was both the court of first instance and also the final appellate court, all wrapped into one. So, of course, in the Supreme Court decision in Skybank versus Iwu in 2017, the Supreme Court, interpreted the Constitution and said no, the industrial court was not a final court, that a right of appeal with leave of the Court of Appeal lies from decisions of the industrial court to the Court of Appeal, and then that is the final court. There's no further right of appeal from the industrial court. I mean, this seems like a very simple and straightforward matter, but up until now, it's still, I don't know how come, despite this decision of the Supreme Court in 2017, we still have people appealing decisions of, in labor law matters from the industrial court to the Court of Appeal, and then when there's a decision in Court of Appeal that doesn't go in their favor, they further appeal to the Supreme Court. I mean, it's surprising, despite how clear the decision in Skybank and Iwu is that there's no further right of appeal, people are still appealing, and I'm sure the Supreme Court would start slamming serious cost on, on the counsel who file such appeals. Perhaps that would finally bring that correction, but it's important to just note that. And then, like I also said, another important implication of the third arbitration, which the Court of Appeal has also interpreted in the case of Sahara Energy versus Oyebola, was a decision given by Justice Ogaku of the Court of Appeal, was that we need to understand that the third arbitration actually changed labor law jurisprudence. So before the third arbitration, we already had a lot of Supreme Court authorities on labor law matters. So one of the very common implications of that was that the Supreme Court had held over a very long period of time that when a person is dismissed or his employment is terminated, the measure of damages for him is actually the what he would have earned within that period of notice that he should be terminated, typically 1 month, or for some employments, 3 months. So what that invariably did was that, as before the third arbitration, you knew that if you took a wrongful termination suit to the courts, usually then the Federal High Court or the State High Court, depending on the sharing of jurisdiction, all you'll be getting will be 1 month's salary as damages, which was very discouraging. So when the third arbitration came, the industrial court charted a new course. I said they're awarding sometimes as much as 2 years gross salary, sometimes even 3 years gross salary as damages for termination. Of course, immediately the Supreme Court made the decision in Skybank versus Iwu. Those decisions of the industrial court are awarded 2 or 3 years salary as damages for wrongful termination began to filter to the Court of Appeal, and a lot of them got reversed. But in Sahara Energy versus Oyebola, what Ogaku JC said there, which is very important to note, is that he said, look, that the third arbitration actually did a radical reform of labor law in Nigeria, and that prior Supreme Court authorities on the matter with respect are no longer good law, because as at the time those Supreme Court authorities were decided, there was no third arbitration that authorized the industrial court to apply international best practices and international conventions, and that those decisions were decisions of the Supreme Court, arising from state high courts and from the Federal High Court, and that those decisions would not be good law within the new within the purview of the application of the third arbitration. So I think it's something important to have at the back of mind. Of course, there's still been a lot of back and forth at the Court of Appeal, but I agree with that decision that if that decision is allowed to stand, even in the UK, what happens is that the superior courts recognize that the labor courts are specialized, so their decisions should be given some more weight by appellate courts. So, it would really be good if that decision of appeal is followed more by the Court of Appeal, where there's more deference. I mean, and Justice Ogumiji of the Supreme Court also gave a recent decision last year, 2022, where she also gave a lot of deference to the decision of the industrial court and re-emphasized the fact that the industrial court is a specialist court set up, by the Constitution, specially to take care of labor and employment. So their decisions should, be given some more weight by the Court of Appeal, and we don't want to just see whole-scale reversal of those decisions. So, Mimi, how many more minutes do I have? I know I'm almost out of time, I suspect. How many more minutes do I have? Because I'm wrapping up now.
3 additional minutes, sir.
3 additional minutes. Thank you very much, for that. So that just sets that framework that the third alteration has, really done something very fundamental in our labor law jurisprudence. So, of course, we have the Labor Act itself, which is the basic law that governs employment. There's still some, strangely, after so many years, it was passed in 1974, there's still a lot of arguments as to who the Labor Act applies to and who it doesn't apply to. So, we know, for instance, that there are decisions that have made it clear that senior management are, not covered by the Labor Act. But then there's still a lot of uncertainty as to who is covered and who is not covered because of the definition in Section 91 of the Labor Act that seems to make the definition of worker as covered under the Labor Act to just be menial and people who do not perform, higher level administrative tasks. But the industrial court, I think, has done a lot of work in trying to clarify the scope of who is a worker, and has, I think, made it clear that the only people who are not covered will be really senior level management. And this is particularly important in union, in union matters, which Bashman will be talking about the more, because sometimes you don't expect the senior management staff themselves, who are on the other side of the table in union negotiations, to also be necessarily covered by some of the outcomes of those negotiations. But it's a thorny area, and I expect Bashman to give us some more context on that. Then, like we said, also, third arbitration has also allowed a lot of international ILO conventions to come in. So some of those conventions, come in and regulate the issue of, wrongful termination. So one common example has been the issue of terminating a person's employment without stating a reason, simply saying your services are no longer required. So there's a popular case of EcoBank versus Bello Ibrahim versus EcoBank, where the industrial court held that you can, under international best practices, you cannot terminate and simply state, that service is no longer required. But however, that has seen a lot of reversals, even at the level of the industrial court. Just, I think 2 or 3 days ago, I still saw another notice of a decision by Justice Adeni of the Abuja Division of the Industrial Court that says, the employer still has the contractual right under the contract of employment to terminate without stating any reason. So it's still an area where there's a lot of arguments, and we expect to soon have a definitive judgment from the industrial court to really tell us whether, the application of the ILO convention on terminating without stating reasons as well. And then there are so many others, and there's so many other laws that apply for discrimination. So, for instance, there's the HIV/AIDS discrimination law, under which we have had the industrial court actually sanction a lot of employers who terminated people just for their medical records because they contracted HIV as well. So there are so many other protections that different other laws, that I may not mention in full here. So things like the Employers' Compensation Act as well, that ensures that workers get properly compensated for injuries suffered in the workplace as well. So at this point, I'll just end, and then when we come back, I'll be able to elaborate some more as well. So thank you very much, Mimi, and back to you.
Thank you very much, Maxi Conway. That was succinct, brave, straight to the point. You covered all of the legal framework. And thank you so much. I know that I think at some point, I think the Leonard Silk would do a bit of justice or elaborate further on the ILO Convention on stating reasons upon termination. Because when I saw that judgment 2 days ago, I was taken aback because I thought we had moved further from that, recently. And then another thing I'm going to prepare your mind for during the questions, I would like for you to touch on a bit of some discriminatory practices. Just a few days ago, I also read a judgment in the UK anyway, where the employment tribunal had that it was discriminatory, so to say, to refer to a woman. So the background is that the employer asked his employee to accompany him to a meeting and referred to, okay, so the message was simply, you should come as XYZ customer is attending. He likes pretty women. And the judge referred to pretty women as being demeaning and all of that, and discriminatory, you know, at workplaces. So you may just think around it so that when we come around to the question times, we could talk about some of these discriminatory practices under our laws. Thank you very much again, I appreciate. So our second speaker this evening is no other than Mr. Bashman Mohammed, who will be speaking to us on collective bargaining. So you would all agree with me that the history of the Labor Day goes back to about 1886, thereabout. And unionism, you know, forged this day because the people came together, the workers particularly came together and said, no, they demanded to work for 8 hours per day. That was the beginning of the Labor Day celebrations. And so we want to look at the power of collective bargaining and all that it can do in various sectors and industries. So without further ado, please help me welcome to the microphone, Mr. Bashman Mohammed for his presentation. Mr. Bashman, if you can hear me, please.
Yeah.
Thank you very much, sir.
Thank you very much. Hope I'm audible.
Yes, you are very well.
Sorry, I lost some of my voice shouting earlier this morning. We had the May Day rally in Berlin.
Oh,
yeah, and thank you very much for the kind words. So I think my assigned topic is collective bargaining and unionization. But in my typical radical self, I cancel the word unionization. Rather, I call it workers organizing, because we've established the difference between just having a union and actually organizing workers for the purpose of collective bargaining. A case in point, sorry, I don't know whether we have in-house lawyer working with the banks here, is what is happening in the Nigerian banking sector, wherein there are unions, but they're actually not organizing the workers for the purpose of collective bargaining. We have the senior staff union and the junior staff union. I don't want to mention their names. All they do is collect check-up due, not necessarily organizing the workers. So my topic, the topic I'll be engaging is collective bargaining and workers organizing. And also to mention that in spite of my affiliation with Solidarity Center, University of Aberdeen and other institutions, whatever I express here is my own personal opinion, so nothing should be tied to any of these institutions. So to make it simple, I think Marx has done some bit of my work by establishing the framework that guaranteed the right to collective bargaining. But I think it's important I stress this, that we have to understand there is this foundational basis for collective bargaining under employment or labor law relationship. Because we don't even want, we in the labor side, we don't want to use the word contract, because attempt to call it a contract is to try to equate it with the normal commercial contract. So we call it employment or labor relationship. So the foundational basis for this is first that there is power imbalance between the capital and the labor. And this created a class struggle. So it's this power imbalance that necessarily we need to have to say, look, a single worker or an employee cannot effectively negotiate with his or her employer. So there's a need for them to come as a collective. And that's why some of us choose the term labor law instead of employment law, because we know employment law is a bit individualistic. So, and then, though Marx has emphasized more on the legal framework, but just to also emphasize a bit is that the ILO convention, specifically Convention 87 and 97, guarantee the rights of workers to organize themselves for the purpose of collective bargaining. And interestingly, Nigeria is a good example on this. Nigeria has ratified both Convention 87 and that of 98. I was bragging early this morning when I was doing my speech that the US has a lot to learn from Nigeria. as we speak, the United States has not rectified that important convention. But here in Nigeria, we rectified as far back as 1960. Also, importantly, is I think Max mentioned that labor right is human right because workers are also human. So there's Article 20 of the Universal Declaration of Human Rights also guaranteed the right individual to associate, and that extends also to the working people. And interestingly also, the process of CBA, collective bargaining agreement, also enable that right. Some workers in their CBA, they have a provision that provides that, look, every two years, every five years, we come back to negotiate. So those are some of the legal framework that provide basis for collective bargaining. Then I think Max also talked about the problem with definition of worker. I think that's section 91 of the Nigerian Labor Act is very restrictive. I don't know why they're still keeping that old law that's older than some of us, but probably not the learned sick, I think. So it's a very outdated law. There's a need to review. And then even in view of our current reality, because at the moment also, I don't want to talk on that much. We are before the Court of Appeal, asking for proper classification of workers undertaking work on the platform. That's the Uber, the Bolt driver, and it's not just a Nigerian thing. But we are just positive that we have good jurisprudence coming from places like the United Kingdom, Canada, wherein those class of workers have been classified as actually worker. So we are hopeful. Regrettably, at court of first instance, the NIC probably maybe they lack the courage to give that judgment, but we are hopeful that something good will come out from the Court of Appeal. Then, I'm talking about workers within the Nigerian context. Some of us on the left felt bad that we limited to the regular 9 to 5, or is it 8 to 4 kind of workers? That's not our true reality. Even by World Bank figures and ILO figures, 80% of Nigerian working class are in the informal sectors. So in looking at workers, our argument is that we should have a broader look beyond those of us doing, we don't believe there's any white collar or blue collar job. Work is work. That's why we call for decent work. So we look beyond that. Even the woman on the streets, we look for social protection for them. So we have a more broader definition of who should be a worker. So that's why if I'm to speak on trade union role in protecting workers' rights, I will not limit it to the right of wages, which is bread and butter issue. We have to extend it to broader social and political issues. Because by the time we say we should limit our discourse to salary and wages, we cannot capture workers that, though some are actually self-employed, or some have been misclassified, especially a case in point is that of an Uber driver, that they are saying they're independent contractor, they are self-employed, but in reality, all indicator of them being under the direct command of the platform owners is there to point that these persons are actually working or taking instruction or command from. I don't want to dive into it because it's a matter before the Court of Appeal. So we are looking at it. So but specifically, since I've been limited to speak on collective bargaining mechanism, so I just have to also do justice to my task so that I will not disappoint the audience. So the Constitution guaranteed that right under Section 40. Specifically, we also have the Trade Union Act, guaranteed the right of 50 persons coming together to form a union. But also that also has a problem of proliferation. Because recently, there's also another confusing judgment from the NIC that initially we used to think that there's judicial scope within the context of Nigerian Trade Union Organizing, that once there's an existing union, another union cannot come up. But I think the jurisprudence coming on from NIC is that freedom of association extends to that. So that's why I think at the moment we have two academic union in the Nigerian university, the Popular I call them popular, sometimes call them notorious. The popular ASU, and then the new one I think is Kony. So this proliferation ideas to us on the left creates not just problem but chaos. How do you negotiate with these types or multitude of unions? There's a problem, and that's why to us, I'm not an anarchist. I believe in law. That's why I studied law, and I'm still doing that at the doctoral level. But we believe that law itself is an instrument of the oppressor, because the existing legal framework is designed to benefit the capital, not the labor. Because I can't pick the specific section. There's a section when I was actively with the union before joining the development agency. There's any time we're trying to go on strike, the minister will say he has arrested, have arrested the situation. I think it's under between 20 something to 25. There's that notorious section. They always arrest that situation without, at the end of the day, we won't get anything. So to us, we believe that the existing collective bargaining mechanism in Nigeria specifically is not for the working people, rather is there to reinforce is there to benefit the capital. That's why we believe, and that what informed my choice of saying that instead of saying unionizing, because we also have yellow unions. I don't want to mention any. We have unions that are just on paper, they are not there for the people. That's why I deliberately choose the word workers organizing. So our argument is this: instead of relying on the legal framework like this, there's what we call institutional structure. The structure that the government, working with the capitals, put in place to further reinforce the capital against the working people. So we believe that instead of relying, we are not saying they should, we exploit, that's the truth. We subject ourselves to it sometimes, but aside that, what we do, because by time you look at ILO Convention 87 and 98, what they say is that you organize first, so before you go into collective bargaining. So we encourage workers to, the first thing you should do, have a union, a formidable union, have the numbers, because it's a game of number. Have the numbers, that's what we call associational power. Have that power. Once you have that power, you can able to withdraw your service. That's when they will feel it. And that's the language sometimes the Nigerian government and even the employers they hear clearly. And they also try to find leverage by looking at the structure. And I think in global north like this, the lessons we are getting is that they use what we call solidarity strike. Example, in fighting that's the right word, in fighting a particular capital, they look at the supply chain, that outside this, which other place can we find leverage to disrupt? Let's say you're dealing with an hospitality, an hotel, for example, and they are not yielding to the demand of the workers. You might choose to get solidarity support from your counterpart or comrades in the transport sector to stop their supply. So that's also using what we call structural power. And lastly, and most importantly, because the world of work is changing, we encourage union, aside relying on the existing collective bargaining mechanism, they should also try or endeavor to use what we call societal power, that's building solidarity with other pressure groups. The world of work is so changing that as an example, I've been off Nigeria over a month now, and I'm still working. So, and it happens everywhere. And the same thing with the platform. I always reference the platform work because that's the future. Everywhere. Because I think interestingly, they said there was a robot lawyer appearing in, I can't remember the jurisdiction. They said the robot lawyer appeared in court. I don't know how true is that, or it's just a newspaper stunt. So the world of work is changing, and that's why we encourage that workers, aside exploring this lay down, collective bargaining mechanism as contained in the Trade Dispute Act, Trade Union Act, workers of this world should also build solidarity first among themselves, find leverage in their engagement. That's where education comes in, trade union education comes in. But regrettably also, we are not doing very well in this, in our own part of the world. We are not in terms of trade union education. And then lastly, also, they should try to reach out to like minds, CSO, community, like in the US, we've seen instances wherein unions work with churches and community-based organizations to get results. So I would love this to be interactive, and that's why I just choose to tease out this. Then when question comes, I think I should be able to provide answer. So I think I will want to hand it over to the learned sick to do what I think a proper lawyer do best. Thank you very much.
Thank you very much, Mr. Bashman Mohammed, for that concise presentation on collective bargaining. We didn't add that he's a lawyer. No wonder he was, reeling out the sections of the law and all of that. Our next speaker is an erudite. I don't want to say scholar, practitioner. He's a top brass, in the legal profession. When you work with a firm such as Templars and you get to that level of partnership, you would understand what it is, I know that Kazim, while he was giving his welcome address, had referred to why we do not have my Lord Honorable Justice O.O. Oyewumi. So, he threw me some, I don't know how to put it, a leeway to come in to say something. So my Lord was supposed to be on this event. Unfortunately, there was a supervening event, and my Lord, couldn't make it to the event today. My Lord extends her apologies. And so on our own behalf, we also extend our apologies to you. We express rather our apologies. But the person who is standing in my Lord's shoes this evening has the competence and capacity to do justice to this topic. He is a practitioner of over 34 years. That's huge, huge, huge. I can assure you that some persons were yet to be born at that time, So I have the utmost humility, or privilege rather, and with utmost humility, the pleasure to invite to the microphone this evening for his presentation. So he'll be speaking from the perspective of legal protection and enforcement, but also as an employer. He's also going to tell you why the employers do the things that they do and why it's so difficult sometimes to enforce our rights as employees. And so it's my singular honor to invite to the microphone at this time Inam Wilson, Senior Advocate of Nigeria. Let's please, if you can hear me, unmute your mic. I am excited and looking forward to listen to your session, really.
Thank you very much. Can everybody hear me?
Yes, we can.
Okay, it's my pleasure to be here. And thank you for the privilege. And the way you emphasized on the 34 years, you made me feel like Methuselah. But trust me, 34 years is not a long time. And I still look forward to many more years of practice of this beautiful profession. I would like to thank Max for a wonderful foundation he has laid, and it was quite interesting listening to Comrade Bashman as well, giving the perspective of the union. And so I will, within the next 15 minutes, try to give the perspective of the employer and, if possible, try to highlight why sometimes the National Industrial Court is hamstrung and unable to do beyond certain limits in in protecting the rights of the worker. Like the comrade, I have also tweaked my topic to emphasize on the understanding the dynamics at play between the rights of the worker and the rights of the employer, and the caught right in the middle. Fortunately for me, in my previous firm, in one of my previous firms, I used to be a human rights activist, so I still wear that hat. And today I am a commercial lawyer, so I have the dual role of human rights and commercial law. I think that's very fantastic. So just to lay the foundation, it's important to understand the dynamics, the forces at play between the employer and the employee. As you would understand, the employer is the owner of the business and he has his objectives. The employee usually begs to apply at the inception. I beg to apply, I humbly apply, so you try to show that you're fit for the job. And I think that is where the problem starts from, because the employer now gives you the privilege and opportunity to serve, to work. And then you come into the system and you want to now be the lord and master of the business. You want to show that you know the business more than the employer. And then that causes conflict. And we live in a world that is driven by economics. And so I'm happy that Bashman mentioned that United States of America, which is supposed to be the beacon of democracy, is lagging behind in some of these ILO conventions. It is not an accident that they are. And the main reason is because United States of America is a capitalist economy, and it is driven by private enterprise. And so private enterprise is antithetical to social and union activities. And so you understand why sometimes they have to take a back seat and look at the commercial perspective. I would like to read something that I got from Simon Dekin, Center for Business Research, University of Cambridge. This is what he said. If labor regulation is a positive sum game for economies at various stages of development, it does not follow that labor law reform is a straightforward process. I should emphasize, labor law reform is not a straightforward process. It would seem that labor law is still a work in progress and central to contemporary capitalist dynamics. I should even add that labor law is a continuous work in progress, as we have seen in Nigeria and in some of the developed countries. Then the ILO itself, in its Declaration of Philadelphia 1944, it said that labor is not a commodity. So this is bringing the other part of it. Labor is not like an apple or a television set, an inanimate product that can be negotiated for the highest profit or the lowest price. Work is part of everyone's daily life and is crucial to a person's dignity, well-being, and development as a human being. Economic development should include the creation of jobs and working conditions in which people can work in freedom, safety, and dignity. In short, economic development is not undertaken for its own sake, but to improve the lives of human beings. International labor standards are there to ensure that it remains focused on improving human life and dignity. So this is from the ILO. The ILO itself, which is the world body that speaks for workers and workers' rights, understands the dynamics. And so every time the ILO tries to set international labor standards and then appeal to countries, mark the word that I use, appeal to countries to first sign these conventions or treaties or protocols, as it were, then ratify them and domesticate them so that they become enforceable. And so if you go to the ILO's website, you will find that a lot of ILO treaties, conventions, some that came into force for much older than me, in the 50s and in the 60s, they haven't been domesticated in a lot of countries, or some just ratify and then they leave it there. So you see how that works. And the ILO does not have coercive power. So what it does basically is to persuade, and it uses its power of persuasion to appeal to countries. So what we find is that there is a constant balancing act between protecting the rights of the employees and advancing the economic rights of the employer. Now, you see that in the case of Nigeria, we operate a free market economy, capitalist, just like in the US. And our economics is driven by certain principles. One of them is market forces. The other is profits, competition, freedom to contract, sanctity of contract, certainty of contract. Comrade Bashman hit forcefully at these things because they are institutional structures, as he said, and I agree with him completely. They are institutional structures designed and set up to protect the balance of power between the employer and the employee. And they are not employee-centric. Rather, they are employer-centric. And so every time that you find that, for instance, we are talking about workers' rights, these are the obstacles, these are the challenges that that you face. And so two things would need to happen in a country for you to say, yeah, they have arrived and their protection of workers' right is up there. One of them is legislation. The second one is judicial activism. When it comes to legislation, I hate to say, and my fellow speakers will agree, that we are lagging behind in so many respects. So many respects. Our laws are principally out of tune with realities. And so we are only trying to catch up with the more advanced, or the more, should I say, countries who are interested in protecting workers' rights. But at the heart of this, at the heart of all the legislation, is international labor standards. That's the benchmark. And Max touched on a lot of these legislations. I don't need to go into them, but the point that I need to make is that we have to constantly fine-tune our laws. We have to, the more we look into our laws, the more we need to see reasons why we need to update them. But unfortunately, as it were, the laws are made by lawmakers. The lawmakers come through a process of election. The process of election is still being fine-tuned. So what do you have? You have a set of lawmakers who do not consider labor issues to be paramount. And so you would find that there are still some bills that have been pending in the National Assembly relating to labor for years. As a matter of fact, the Labor Act that we operate which is over 50 years or thereabouts, we have been trying to update the Labor Act. It has not seen the light of day. So many administrations have come and they have gone. It hasn't seen the headway. Don't ask me why. But you see, the countries that Mr. Comrade Bashman will refer to as the frontliners, you will see that a lot of them, they have laws that regulate labor activities, workers' rights. The reason is this: when you have a law, when you have a statute, you have done half of the job. What is now left for the court is to interpret the statutes. But if you don't have a law in place, the court is hard-pressed. The court needs materials. It needs something upon which it can build this decision. And if there is nothing, the court is helpless. And so it will only take a lot of ingenuity from the side of the court to be able to do that. And that ingenuity was provided by the third alteration in 2010. And so what the National Industrial Court has done is to try to fill the lacuna, the gap between legislation and decisions, to say we have the right and the power to apply international best practices. We have the right and the power to apply and construe international conventions, treaties, protocols that Nigeria has ratified. And then they use that as a platform to now make decisions. So you find that I have to commend the court for this courage. In the old regime of the military, some of you who are young, you didn't quite experience the military regime, but in the old regime of the military, that would not have happened. But in today's civil dispensation, the National Industrial Court can be aggressive, can be innovative, and they know that the only check that they have is the Court of Appeal, and that's a very civil process. So international standards remain the benchmark, and like Justice Kanyip said, international best practice in labor or industrial relations are almost always mirrored in the light of the conduct of the employer. So the court will look at the conduct of the employer and say, oh no, this doesn't meet the standards. Or to say, yes, this meets the standards. And what helps the court in determining what those standards are? They are international conventions, international treaties, and protocols that Nigeria has developed, as ratified. A lot of those conventions we only ratified, we have not domesticated, but I think the third alteration gave us the way to circumvent Section 12 of the Constitution, which requires domestication. So like Justice Kanyip said, Justice Kanyip, by the way, for some of you, is the president of the National Industrial Court. He has said that a quiet revolution is going on in the National Industrial Court. The jurisdiction of the court is invoked not for the enforcement of mere contractual rights. Comrade Bashman pointed out in his presentation, he talked about trying to avoid using the word contracts, because that is already tilted against the worker. But that's what it is, that's our reality. So they are contractual rights. And Kanyip is saying that the duty of the court is not just for the enforcement of contractual rights, but for preventing labor practices regarded as unfair. So sometimes we find out the court goes beyond the mere ink, the mere letters of the contract, and tries to say this practice, even though it is in your contract, is unfair. And it's on that basis that a lot of practices have been declared to constitute unfair practices. So the courts, in fairness to it, have laid some very, very, what I'll call far-reaching key markers in the areas of discrimination at the workplace, in the areas of the right to hire and to fire, in the areas of privacy, protection, outsourcing of contract, unfair labor practices, and international labor standards. The court has done quite a lot extensively. I'm sure in the course of this conversation, we'll talk about them. But the court itself understands that it is a court of law. Therefore, it can only act within the ambit of the law. We say that the court is supposed to act judicially and judiciously. And so for that reason, the court also understands that there are certain limitations that it has. And these limitations has to do with the rights which the court have not been able to find a way to negotiate or go around, which are the inviolable rights of the employer. And some of these rights, I'll just mention them in the interest of time. So I mentioned the right to hire and to fire. There's a common law principle that you cannot force a willing employee on an unwilling employer, except it's an employment with statutory flavor. So that is still there. The employer has that right to hire and to fire. And Max mentioned the decision of the industrial court about whether you need to give a valid reason to terminate. I think I've been involved in that as well at the industrial court and at the appellate level from the side of the employer. And basically, the argument we keep making is the contract that you signed from the beginning has given me the right to terminate by giving notice. So why can't I terminate by giving notice? The contract does not say I need to provide a reason. There are circumstances where the contract itself says that, oh, I cannot dismiss you unless for cause. And then the contract spells those out. In those situations, I'm duty bound to comply with what my contract says. So a balanced contract will have provisions that protect the employer and provisions that protect the employee as well. So that is an important part of the right of the employer. Then the right to discipline. Those who are comrades and his fellow freedom fighters, they don't like being disciplined. Once you belong to a union, you have immunity. So you don't touch a union member with a 100-foot pole because they are immune from discipline. But that's the right of the employer to do. And so unless it is there's a clear case of victimization or you're being disciplined because of your union activities, you should be able to subject yourself to the right to discipline, you know. And then, of course, the current trend is unions intervening in an employer's intention to sell its business. So I am aware recently, some employers want to sell their business. And the union said, no, you can't sell your business unless you settle us. But there is nothing in the contract, there's nothing in the CBA, there's nothing in the agreement that says you're entitled to a certain payment if I'm selling my business, because it's my business. No, you can't do that. And that has become a trending issue. I think it has even gone to court in some cases, but you know, it's still the employer's right to sell his business to it and its undertaking, right? Then the right to manage the business and to reorganize the business as it is expedient for it to do. So the rights are quite many. I see that I've gone beyond 15 minutes. I would like to respect the organizers and I'll take questions when they arise, you know. Thank you very much for your time.
Thank you very much, Leonard, for that elaborate presentation. I was just smiling out here. I enjoyed every bit of it. Thank you for the rights that you've mentioned. I am curious, as we enter the question and answer session, to hear the conversations, the engagement that would arise, basically. with regards to you as an employer, sir. So we are now at the Q&A juncture, and so we will now call for questions, comments, and observations for our speakers. So I remember that I had hinted Mr. Max that I was going to request of him to make certain comments regarding the authority. I said I read, in the UK with regards to discriminatory comments, so to say, that the employment tribunal had. And so I wanted to find out where we could situate that in our own jurisprudence, here and all. So I don't know if you have any comments to make on that, Mr. Marks, before we proceed.
Oh, okay, yeah, thank you very much, Mimi. I mean, Bash and Bashman were, on the group of the Employment and Labor Law Association of Nigeria, and I mean, that was a hot issue when that decision came out. I mean, of course, reading the headlines alone, it sounded rather ridiculous, but when you go into the context of the case, because just as we've mentioned here, and even the leadership also mentioned that when it comes to employment matters, it's a little bit beyond contract and beyond just the commercial and economic reality. There's also the livelihood question, because this is also, a human rights issue. So if you look at that decision within the context of how that decision was said, you could actually situate decisions that are not far off it in our jurisdiction that may not exactly be the same, and you can extrapolate and see, if that same situation arose in this jurisdiction, where the court would be likely to go. So we have cases here in Nigeria where the issue that people are employed and, for instance, given targets, the industrial court has been very clear on it. You can't do that, because that crosses the line. So when you read this UK case, you see, for instance, that clearly what the employer was hinting at was clear, that, look, we're using you as a human bait to really get these clients in because of your your looks. So I mean, and there's also the cultural context. So I mean, for those cultures, sexism is a hot topic. Feminism and all is a hot topic, and definitely there's no law that would succeed if it is separated from its cultural context. So if sexism is a huge issue there, then we expect that cultural issue would also seep into the jurisprudence of the court. So I would want to imagine that even in a place like Nigeria, if the same situation arose and say the employer tells the employee, you have to be there because of your looks and, and all of that, and maybe the employee resists and, that employee is terminated, then I would expect that. And you need to also remember that the Industrial Court Rules 2017 actually takes the issue of harassment and, such issues quite serious, that there's even a whole order, as to cases brought for harassment, particularly sexual harassment. So I would expect that even here with those kinds of positions, that the courts will take it as a serious matter. But like I said, the headlines initially, of course, made the matter look strange. It was like, just telling somebody you are pretty becomes a problem. But of course, it's about the context. So as you read the context, then you understand that it was beyond just a compliment. It was clearly, sexism, which crosses the line. Thank you.
Thank you very much, Max. Thank you. From your answers, I could draw some connection with what the learners have said. So I'm wondering in my head, if we have authorities that say that giving an employee a quota, something to meet, and then I'm looking at an employee who is desperate to get a job, and then there's a contract that he or she has signed. And if that is in the contract, are you saying that I cannot come seek a redress because, I mean, from the employer's perspective, I signed the contract? So that's a dilemma, so to say, for an employee. And I'm wondering how we are supposed to get past this, like manage it so that it's a win-win situation for us. So I don't know if the learners can actually come in here and help us out. How do we as employees manage this circumstance?
Okay. In fact, I'm so happy you brought this up, because when Max was speaking, I was just saying, this is a very good issue. This is a very important issue. And now I will not speak as an employer. I'll speak as a worker now. So I know of certain businesses in certain sectors that are target driven. As a matter of fact, I know of a company that employs pretty ladies. I mean, you have to be really, really pretty, and gives them targets and say, go into the world and get money for us. These things are in the contract. So you have milestones. And so I found out that they are employed in batches. It could be batches of 50, it could be batches of 20, as the case may be. And they are put on probation for 6 months. By the end of the probation period, because the targets are so unrealistic, those targets cannot be achieved unless you compromise as a lady, because they are not targets that depend on, what should I call it, the bankability of the project. So it's not something that, oh, people, once they hear about it, they want to rush. Oh, I want to invest, I want to invest. The first question they always ask, why should I invest? And now you've set impossible targets for them. And they are desperate because they need the job. And so you find out that within a period of 1 year, they would employ maybe 100, all the 100 will go. And I said to myself, I wish I was an employee's lawyer. I wish I was Max, in Max's position. I would have gathered all of them and gone to the National Industrial Court. Because like I read what Justice Kanyip said, the role of the National Industrial Court is not just to interpret contracts. It is also to look at the practice and to determine if the practice is fair. We all have daughters, we all have sisters, we all have friends who are female. We will not permit any of them to be subjected to such practices in a normal and sane environment. And so that is a clear case of unfair practice, but somebody has to take it to the industrial court. And it is for that same reason, that is the context behind why the industrial court struck down the practice of giving marketers, female marketers in banks and financial institutions, targets. Because it's unreasonable. You're not selling a product, you're selling people. You're selling female bodies, all to make money, which is unconscionable. I think that has answered the question. Thank you.
Thank you very much, Leonard. So that has answered my question. I wanted to do a follow-up, but I would refrain from doing that. I have a question from Mr. Bashman that says, currently the Nigerian minimum wage is not in tune with the cost of living across different states. What would you advise the workers to do legally, especially those employed in the formal sector? You talked about collective bargaining. So let's hear your advice for these sectors, what they can do.
Okay, I agree the minimum wages. I think there's a newspaper report that currently Nigeria is paying the least minimum wage in the world. By the time you do the exchange rate of 30,000 to $1, you'll be getting just $23 in a month. So that's the least in the world as of this morning. So happily, the organized labor in Nigeria are currently engaging with the federal government, but now talking about the private sector, the formal sector, which I think should be the private sector now. That's why in my presentation, I emphasize the need for unions and workers on themselves to collectively organize themselves. The idea that capital-owned business is because we are not doing it properly. We've seen big multinationals begging workers that, look, when they done too, and they done too effectively, we see them coming to say that, look, let's talk. So the way out, I don't want to say I'm a pessimist. I have little faith in the institutional structure. That's the truth. Because it goes beyond just the court. there are other things involved. And that's why our argument is that workers of this world, Nigerian workers in particular, should organize themselves strongly. If they have the number, look, ASU is not doing bad in terms of getting what they want. The 8-month withhold salary, the government is secretly paying that money. I can tell you for free. It's the product of them organizing themselves effectively and looking for good leverage to engage their employer. And please, just to add also, on the issue of the sexual harassment, there's a legal framework now in Nigeria to actually test that kind of case. Nigeria has ratified ILO Convention C-190, and that convention is wide-ranging. So, verbal communication like that falls under that convention. And if we have a similar scenario in Nigeria, I think the aggrieved worker can actually seek for redress. So to address the question on how effective they can do that, I think the way out is for the workers to effectively organize themselves. There they can have leverage to get a good deal. Because if we don't organize, we keep on agonizing. So that's my simple answer to that.
Thank you very much. The members should organize themselves to push forward their demands as much as possible. So there was a question about a bill at the National Assembly. I don't know who to direct it to, actually, but let's see now. So recently a bill passed the second reading at the National Assembly seeking 5 months leave for widows. Do you think this can fly in view of the fact that 80% of employers in Nigeria or employees in Nigeria are employed by the private sector? I think Leonard Siku, who spoke on behalf of employers, may attempt to take this on, and then Mr. Bashman, who is also may help us out. Leonard Siku, sir.
That's a very sensitive topic. Widows who have lost their husbands. 5 months leave. Okay, all I can say is maybe let us see what is still a bill. Let's see what comes out, because at the end of the day, bills have a way of metamorphosing, and what was sent in may not be what comes out. And I would also like to understand the thinking behind it. Does even the woman herself want to be at home for 5 months, especially if it's a working class lady? So there are things to be considered on both sides. But when the bill comes out, then we'll know exactly what it is. I'm sure the representations will also be made, but maybe I should use this opportunity to address the point of the things that are important that we should be focusing and driving vis-a-vis the things that are not so important. Everything is important, but some are super important, some are not so super important. I believe that, for instance, outsourcing, Comrade will agree with me, outsourcing is a major issue, especially in the private sector. We need to have a definitive law on outsourcing in Nigeria. We don't. Those are some of those things that the National Assembly should be pushing. Then we know that they are serious about it. I know a bill went through trying to deal with, what's it called? Max, help me here. Okay, I'll remember shortly, I haven't seen, the bill hasn't come out. Casual workers, that's what I was trying to remember. A bill trying to outlaw casual workers and regulate casual workers. It hasn't come out. Max, or has it come out? I'm not aware,
No, it hasn't. The bill on
exactly.
against casualization of employment.
Casualization of, it hasn't, that's a very important bill. It hasn't come out. Something to define who a worker is. It hasn't come out. There's nothing there. The labor standards bill that's supposed to deal with discrimination, it hasn't come out. So there are important things there that they are not paying attention to because it's not popular. I think I'll stop there for now.
Thank you, Leonard. Mr. Bash, okay, I see you doing thumbs up.
Yeah, I think I will rest my case on that of the learned C. For once we're on the same page.
Absolutely. Thank you very much. Our very distinguished speakers, ladies and gentlemen, we have spent by my time 1 hour, 30 minutes, and that is beyond that is totally beyond what we had planned for originally. We just wanted to spend an hour or max 1 hour, 20 minutes. So, but we thank you so much. It's been very engaging. I see someone sending in a question here, but we can't take it, unfortunately. Please bear with us at this juncture. We need to call it a day. I want to thank you so much for all that you have done. We thank you for being here with us. But to do this properly, please help me welcome to the microphone to take the vote of thanks this evening, the principal partner for T.T. Kalio and Co., my friend, sister, support system, and colleague, Tamino Tonye Kundayo. Tamino, if you can hear me, TTK, actually, if you can hear me, please come up, please.
Good evening, everyone, ladies and gentlemen, esteemed speakers and participants. I would like to express my gratitude to each of you for making this webinar on workers' empowerment a success. Our speakers, Max Ekongbe, Mr. Bashman Mohammed, and Inam Wilson SN, have shared their expertise and experiences, enlightening us on the importance of workers' rights and responsibilities. We say a big thank you to them. And to our participants, we say thank you for your engagement and thoughtful questions. Your contribution has made this webinar a huge success. Once again, we say a very big thank you for your time, your expertise, and enthusiasm, and we wish you a fruitful day ahead. Thank you so much.
Thank you very much, TTK. I appreciate it. That was very direct to the point. So I wanted to, before releasing everybody, I think I saw that observation and I think that it is very important that we release it. Since the minimum wage is not enough for workers, can employers look at the possibility of rotating work time of employees? That is, the worker to work for 2 weeks in a month and use the remaining 2 weeks to look for alternative work to supplement pay. I think that is quite very instructive and helpful. So I wanted to just read that out, you know, to the participants. At this juncture, thank you so much. We have come to the end of our session today. We look forward to hosting you all again at a different forum. We share materials where they are available. Thank you so much. It's been an extreme pleasure moderating this session. My name is Mimi Ayua. I am the managing partner for Wells and Pitchers Law Practice. Thank you very much, and it's good evening once again.
Thank you.